Um, yeah, so before I begin, I think it's imperative that we keep in mind the fact that tort law is based in principles surrounding the protection of individual integrity. And as such, every decision taken in tort should be taken with the aim of improving the state of individual protection by identifying all rights relevant to said integrity. It doesn't take much explaining to communicate that this is a case where Stephanie's rights have plainly been attacked, and an efficient legal system should be able to protect them. This is not to say that there aren't remedies for Stephanie's claim. However, in my opinion, these need be expanded just a little bit more. In Wilkinson versus Downton, the defendant told the plaintiff that her husband had been in an accident, circumstances that are very similar to these. As a result, the plaintiff suffered a traumatic shock that also resulted in illness. In the ruling, Justice Wright stated that the defendant attempted to infringe her right to personal safety. In his view, this constituted grounds for action as there was no justification for the alleged act. Although Downton did not wholeheartedly intend to cause harm, any claim in negligence would not give rise to action as set out in the Victorian Railway case, because nervous shock was too remote a consequence of a negligent act to be a recoverable head of damages. Instead, he devised a sort of imputed intention that pointed to the foreseeability of consequences as justification for intention. This case draws most parallels with Stephanie's, as Michael did not wholeheartedly intend to cause the harm that he did, but he should have understood that such news would have serious effects on any but the most indifferent of people. There is also no known justification for the act, thus an intention to cause such effects can be imputed to him. If it can be discovered that Michael was aware that Stephanie's extreme reaction was likely due to the past relationship that they have, as she mentioned, then this should also be grounds for imputing intention. It must be said that this case does not provide remedy for anything less than causing psychiatric injury. But what exactly falls between those lines is the question that we must continue to ask ourselves. The courts need to clarify this. Is one required to have been hospitalized? The scope of psychiatric injury can be so vast, if thought about thoroughly, that the intention of the defendant should have a greater weight in terms of considerations. Wainwright versus Home Office dismissed the idea of a tort of imputed intention based on the decision in Wilkinson, as Lord Hoffman stated that the case had no leading role in modern law. He stated that it would be better off that the case was buried in the law of nervous shock caused by negligence, as the climate within which the decision was made is currently irrelevant. However, reasoning within the case suggested that tort of intention to inflict emotional distress would be welcome. Hoffman also stated that if someone actually intends to cause harm by a wrongful act and does so, there is ordinarily no reason why he should not have to pay compensation. The question that the court will ask is if the distress that Stephanie felt was enough to amount to compensation, and herein lies the issue. We are reminded, the statement goes on to remind us that damages for mere distress are not recoverable. And I am reminded that distress in itself is a flexible concept that can range from the slightest of inklings to fainting and will vary from person to person depending on the stimuli. And hence, compensation should be more heavily based on the tortfeasor's intentions than currently allowed. Stephanie's only remedy would be through negligence, with Lord Hoffman again stating that there is no need to consider intention if negligence will do just as well. Another option is the Protection from Harassment Act 1997. The Act states in Section 1 that a person must not pursue a course of conduct which amounts to harassment of another, where harassing is defined as causing distress to or alarming another. Also, he ought to know the amount of harassment that would cause Stephanie to react in certain ways, again due to the fact that they dated for 6 months. Proof of this knowledge, however, remains to be seen. This could very well apply to Michael, although the Act also states that course of conduct must refer to acts carried out on at least 2 occasions. It also remains to be seen whether or not this is the first time Michael has engaged in such behavior towards Stephanie. According to Lord Justice Hale, before the act was passed, there was no remedy for anything less than physical or psychiatric harm, further highlighting the failure of the law at this time to efficiently protect all aspects of an individual's integrity. The law is too focused on an outcome that is difficult to define and therefore leaves way for people to fall through the cracks. Lord Hoffman finished by saying that people constantly do and say things with the intention of causing distress to others, and then pointed out that litigation might not be the right way to deal with it. And he may be right. There's a growing fear amongst academics that the legal system may begin to impose itself on issues which would once have been considered everyday dealings between people. This represents not only an administrative problem, but could have a major impact on societal interactions as we know them to be. In the case of O versus Rhodes, or O.A. Child versus Rhodes, Baroness Hale and Lord Tolson stated that it was common ground that the consequence required for liability is physical harm or recognized psychiatric illness. I think it's worth mentioning that the use of the word recognize is as dangerous as it is flexible, and further highlights why torts for intention to cause emotional distress is needed. I'm unsure whether what Stephanie suffered counts as an illness, but we have seen the courts use words such as shock, distress, as well as illness, leading me to feel even more like someone will suffer the for emphasis having been put on the consequence. Once again, the scope of psychiatric illness or shock is too wide for us to be able to fully recognize it each time. Hence, emphasis should be given to the intention of the person that causes the shock. If there was no intention, this may fall under negligence, but if there was a separate tort, a separate tort should be established, especially in cases such as Stephanie's, where the defendant claimed to be joking. Lord Neuberger said it best: the fact that a statement is intended to be a joke is not consistent with the notion that it was intended to upset. The defendant intended to cause the claimant distress, jokingly or not, and should be held responsible for any consequence of this based on that intention and not the other way around. He then laid out points for establishing whether a statement which causes a claimant distress should give rise to a claim. The statement must be untrue and gratuitous. There must be an intention to cause the claimant distress, and the statement must be directed at the claimant. Michael's statement was untrue. It remains to be seen if he had any reason. We established that joking is not inconsistent with causing distress, hence it can be concluded that this was his intention, and it was very clearly directed at Stephanie. Based on previous cases, Michael is liable, but as long as the 2 days Stephanie spent in hospital qualify as recognized psychiatric illness. We are beginning to see weaknesses of relying on consequence as opposed to intention. Once again, Lord Neuberger said it best: it is not entirely easy to see why, if an intention to cause the claimant significant distress is an ingredient of the tort and is enough to establish the tort in principle, the claimant should have to establish that he suffered something more serious than significant distress before he can recover compensation. Thank you.